Today we are going to speak about immunity and impunity. These two words do sound alike and they are spelled very similarly and are often used together to create an effect. And in fact, they have a rather similar meaning in that they both refer to some sort of protection. However, impunity is a much narrower word. It derives from the Latin words which together mean not punishment, and it means protection from punishment or from any harmful consequences of an action. So, for instance, it is often said that the mafia operated with impunity for many years because of the cooperation of corrupt police officers. It is often said that having freedom of speech gives us impunity for any statements, and we might make that against the government. The word immunity refers to protection, not just from punishment, but from a duty, from a liability, or even from an illness. So there are popular phrases in which the term immunity is used. For instance, diplomatic immunity. We also have the concept of executive immunity, and that refers to a system in which, in some countries, presidents and vice presidents and other people at the top of a government are protected from any kind of criminal arrest or punishment or charges. This derives from the earlier sovereign immunity, which protected kings and queens from any kinds of criminal punishment, based on the idea that the king was someone divine and the king could not do any wrong. These ways, executive immunity is considered to be a very undemocratic system, and it is not widespread in the Western world so much. Then, of course, there is the concept of immunity from prosecution, and that occurs typically in a criminal case when there is a co-conspirator in the crime who maybe knows a lot of important information about the crime that the prosecutor would like him or her to testify about the trial. However, this particular witness or co-conspirator is afraid that if he or she testifies, he will say something incriminating. Therefore, in order to get this person's testimony, the prosecutor grants immunity from prosecution to this witness. Now, a few words how precedents are established. That's a kind of historical thing we're going to speak about. A precedent is a ruling that a judge has to follow when considering a case that raises similar legal issues. It is a foundation of common law legal systems. So, how are precedents established? In England, all criminal cases begin at the magistrate's court, and serious cases then get sent up for trial at the Crown Court. And the Crown Court is the first major criminal court in the United Kingdom. When the case is settled, that's then set a precedent. If the prosecution aren't happy with that, they appeal the decision. It goes up to the Court of Appeal, the criminal division. Now, the Court of Appeal can uphold the judgment of the Crown Court, or they can overrule it. If they decide to overrule it, what then happens? The final Court of Appeal within the United Kingdom legal system, before going on to Europe, is the Supreme Court, and the Supreme Court could uphold the judgment of the Court of Appeal, or they could overrule it and reinstate the original judgment. If they decide to reinstate the original judgment, that's then set a precedent. The Supreme Court is generally bound by its own decisions. there are certain circumstances under which it will depart from previous decisions, but for reasons of predictability, it's very important that, as far as possible, they stick to their own decisions, and all lower courts have to then follow that precedent. Thank you. Lease. Lease is a confusing term for some people because they don't quite know how to use it. Firstly, the verb lease. Who leases property? Well, the landlord or lessor leases property to the tenant or the lessee. A landlord is the owner of a building or a house or an office space, for example, and he leases it to the tenant and the lessor. That's a wider term. That means the person who either owns the property or a building or also owns the equipment or a car or something like that, and they lease the property to the lessee. When we talk about leasing, we are talking about renting out to someone. An example of that could be used in the following way. The landlord agreed to lease the property to the tenant, so note the use of the term lease to in that sentence. Conversely, you can also talk about the tenant or the lessee leasing property from someone. So the tenant leases from the landlord and the lessee leases from the lessor. Basically, it means that they are renting it from those people. Bear in mind that individuals and legal entities can be landlords, tenants, lessors, or lessees. A legal entity being something like a company or a partnership. So you can see that the verb lease is very flexible and can be used by both to show that both lessors are leasing to someone and lessees or tenants are leasing from someone.